Hi, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and this week's contract tip has to do with the type of warranty deed that is conveyed between the buyer and the seller in your real estate contract. So in both the GAR contract forms and the RE contract forms, the type of warranty deed that is pre-printed in both sets of contracts that is conveyed by the seller to the buyer is by limited warranty deed. So the GAR contract in paragraph B1 states, warranty. Seller warrants that at the time of closing, seller will convey good and marketable title to said property by limited warranty deed, subject only to, number 1, zoning, number 2, general utility, sewer, and drainage easements of record as of the binding agreement date, and upon which the improvements do not encroach. 3, declarations of condominium and declarations of covenants, conditions, and restrictions of record as of the binding agreement date. And 4, leases and other encumbrances specified in this agreement. Buyer agrees to assume seller's responsibilities in any leases specified in this agreement. In the RE contract forms, all of this is spelled out in the standard terms. So as you know from previous videos, in the RE contract forms, they have abbreviated the actual purchase and sale agreement to 4 pages, and it references the standard terms. If you are a Maximum One agent, you know it is our policy, and if you are any agent, it is good business practice to go ahead and print out the standard terms and attach them, reference them as an exhibit, and attach them specifically to your contract. But so that's where the warranty deed is explained in the RE contract forms. It is in the standard terms for purchase and sale of Georgia real property. And in paragraph 1, it states, seller shall convey to buyer good and marketable title to the property by limited warranty deed, free and clear of all mortgages and liens, except the property shall be subject to the taxes not yet due and payable, and all other encumbrances, zoning ordinances, easements, and restrictions of record as of the acceptance date of the contract. So that's the type of warranty deed, limited warranty deed versus general warranty deed. So just so you know the difference, the GAR contract forms changed in about 2014, and the RE contract forms, I believe, has always conveyed limited warranty deed. But GAR used to convey general. It changed in the advent of the boom in the foreclosure market, where the foreclosure banks owned the properties that were being sold. So basically, general warranty deed, the seller warrants the title to the property from the beginning of time. In a limited warranty deed, the seller only warrants the title during their ownership. So if there is a defect, regardless of the cause, in a general warranty deed, the buyer has the option of proceeding against the actual seller if it was even prior to the seller's ownership. Just as a practical matter, if there are any issues with title, typically the new owner will pursue those issues through title insurance. You guys make sure your buyers are getting title insurance. So which type of deed is better? Can you change it? Well, you can change anything by special stipulation. In general, it depends on which side of the contract you're on. If you are a seller, it is definitely more protective of you if you are conveying limited warranty deed. If you are a buyer, you probably would want general warranty deed. That is a discussion to definitely have with the closing attorney, and depending on the title, anything that comes up in the search. So that's the type of warranty deed that is conveyed. The second thing, let me just briefly touch on good and marketable title. What your buyers and sellers tend to think is that good and marketable title means that the title is insurable. That's not what it means at all. It means specifically good and marketable is defined as a title in which the title insurance company licensed to do business in Georgia will insure at its regular rates, subject only to standard exceptions. And that definition of good and marketable title is in both the GAR and the RE forms contract. So it has to do with the price of the title insurance policy. It has nothing to do with it being insurable or not. And different title companies and different title insurance companies, just like any kind of insurance, are going to have a different risk tolerance and different rates based on their whole portfolio, their risk tolerance level, and what they choose to charge. So you need to check with the closing attorney to find out what title insurance company they write title insurance for. And there might be one title insurance company that, let's just say, for example, there's a utility easement that runs across the front yard of the property 50 feet from the front door. Let's say it's a gas line easement. Well, one title insurance company might have a bigger portfolio, have a higher risk tolerance, and be able to insure that title at good and marketable title with no additional rates to the premium. Another insurance company might be a smaller company, might have had more claims against them, for whatever reason, may not insure that property at standard rates. They still might insure the property, but the premium is going to be a little bit higher for that. So that's, again, another issue to have a discussion with the closing attorney, and depending on which title insurance company they're writing for. And then the third issue I want to discuss is, well, what if there is an issue with title? What if there is a title defect or a cloud on title? What are the responsibilities of the parties as they pertain to the purchase and sale agreement? Well, if you've ever taken any of my contracts classes, you know, you've heard me say repeatedly that the contracts are nothing but a set of instructions for everybody as to how to proceed. So let's see what the instructions say. So in the GAR contract, again, we're on the actual purchase and sale, and it is paragraph B1B, where it talks about examination of title. Buyer may examine title and furnish seller with a written statement of title objections at or prior to the closing. If seller fails or is unable to satisfy valid title objections at or prior to the closing, or any unilateral extension thereof, which would prevent the seller from conveying good and marketable title to the property, then the buyer, among its other remedies, may terminate the agreement without penalty upon written notice to the seller. So a couple of things. The buyer has the responsibility to check in with the closing attorney who did the title exam to find out if there are any title defects, encumbrances, anything that has to be cleared up. If there is an objection, the buyer needs to send written notice. You've heard me say in previous videos, you guys need to use those notification forms in your set of contracts. This is a perfect example of when to use it. So to meet the terms of what the contract says, the buyer needs to send written notice to the seller of what the title defect is to allow the seller to remedy that defect and then convey good and marketable title, or else the buyer may terminate. But again, that notice is very important as outlined in the GAR contract. In the RE forms contract, this is all described again in the standard terms, which is form RE1 versus the purchase and sale in the RE forms is RE100. And this is in paragraph 5.1. Clearance of title defects. Title defects are those defects required to be remedied by the title insurance company, insuring the title to the lender, if any, or to the buyer if an owner's policy is requested by the buyer. Seller shall be responsible for the removal of any liens encumbering the title and any legal fees, recording, or other costs associated with title curative work. So again, you guys, make sure you understand what the type of title is that the buyer and seller are conveying, and how to work through any issues with that. It is all outlined in the contracts. Any specific questions, make sure that you have a discussion with the closing attorney and with the title company so that all of that can be cleared up, and put your buyers and sellers in touch with the closing attorney so they can answer their legal questions. Thank you so much for watching. Again, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.